Good morning. Today I want to discuss with you about how to disprove the genuineness of FIR, because the Simon against Supreme Court and other courts held FIR is not a substantial piece of evidence, only corroborative evidence. That means at the time of filing FIR, the informant may be at confused stage hurriedly giving some complaint. And it is the duty of the investigating officer, by exercising power under section 161 and 162 CRPC, by recording his statement, bring the facts to the court to strengthen the prosecution story and to proceed with the fair investigation. Number one, 154 CRPC warrants two persons. One should be an informant, other one should be recording officer. So sometimes what happens, the investigating officer himself, the officer who he himself gives a complaint and he himself records itself. Several times it was held that is not legally correct. And the time it is a very good case for time and again the courts to look into the matter whether such investigation is valid or not. That different issues. But the 154 CRPC commands that the information should be recorded in two ways. Number one, if the informant, that means complainant, gives in writing, that should be recorded in printed FIR. He have no right to alter that FIR. On contra, if he gives oral, it is his duty to reduce it in writing, then read over to him, and after having understood the contents of the complaint which he was narrated orally, then get signature or thumb impress whatever, then he has to write it in printed FIR. Sometimes if you put a question to the person, who wrote this complaint, they say, I do not know who wrote it. Sometimes he may say, some friend has written that, or some police officer has written that. So if the FIR, printed FIR did not contain the statement that the oral complaint was reduced in writing and read over to the complainant, that FIR is doubtful. Possibility of tainting at the instance of that party, that must be kept in your mind to suggest that, see, whatever it may be, you may raise doubt, you may raise contradiction, you may raise tainting investigation, but you have to say in what way it is prejudice to your case. So you, at the time of filing, at the time of final session, you may say that by tainted FIR, by irregular FIR, or by registering the FIR contrary to 154 CRPC, the complaint was exaggerated or at the instance of third parties forged against the accused. That would be your fair and most assertion. Another aspect was the time of FIR and the registration of FIR is vital. If you have any doubt, you can call for general diary of that particular police station, which is being written by around the clock. Suppose if your FIR is claiming to have been registered so and so time, that would have been written in the general diary. So you, at the time of examination of investigator, you can file an application under 91 CRPC to call for the general diary. At the same time, you can also call for prisoner search register, PSR, available at the police station. There also you may find when the accused was arrested and put in the prison. That particulars may be available, wherein you can also get the information The information of arrest was communicated to whom, and if that was communicated to that particular person, why he was not whether he is an eyewitness or not, so many things you may create doubt. So this much of vital aspects you have to consider for FIR. Then some FIR are being forwarded by magistrate, that will be well drafted. Still you can raise certain doubts that allegations in that FIR was over enthusiastic, biased. All these things are, you may be that motive is double-edged weapon. Because of that motive, accused would have committed the offence. Because of that motive, accused was falsely implicated. Therefore, it is a double-edged weapon. Best wishes.